This is presenter for Shariah Audit for today. Today, we are presenting. The first is overall Shariah governance framework and introduction. Next, objectives and importance of Shariah audit. The third is level of approaches. The fourth one, current Shariah audit practices and cases. The fifth one is challenges in Shariah audit. Last but not least, recommendation and conclusion.
First, I will explain about the definition of Shariah governance framework. It can be defined as a system for Islamic banks to monitor, oversee, and perform their operations. The Shariah Advisory Council of Bank Negara Malaysia (SEC) is a council formed under Section 51 of Central Bank of Malaysia Act 2009 to determine Islamic law for the purposes of Islamic financial industry. The SEC's duties including determining the applicable Islamic law on any financial institution and issuing a judgment upon referral, as well as advising the bank and the IFY on any Shariah matters pertaining to Islamic financial business operation, activities or transactions. In the case of IFR in Malaysia, the Shariah governance framework issued by the Central Bank Malaysia (PNM) is employed. Islamic banks in Malaysia must nominate and appoint SSB members who are qualified in Shariah matters and are responsible for liaising with other boards of directors to verify that the banks are functioning according to Shariah principle. What is the objective of this framework? The first objective is to improve the board Shariah committees and management's roles in Shariah concern. Second is to help the IFI set up their governance system and increase accountability. And the third one is to further build a Shariah-based and operating environment. The Shariah governance framework is primarily concerned with the following topics, which are the form of Shariah governance, elements of Shariah governance, and Shariah compliance and research functions. The organization of Shariah governance function is to establish Shariah governance structures, procedures, and arrangement for IFIs to ensure that all operations and commercial activities comply with Shariah. The elements of Shariah governance help to provide thorough assistance to IFI boards, Shariah committees, and management in carrying out their responsibility on areas of Shariah. Shariah compliance and research functions describe the duties of Shariah review, Shariah audit, Shariah management, and Shariah research are described. Next is introduction to Shariah audit. What is the definition of Shariah audit? It can be defined as systematic procedure of acquiring adequate and relevant evidence to make a judgment about whether the subject matter corresponds with Shariah norms and principles widely acknowledged by stakeholders and general society.
And I will be presenting about the objective of Shariah audit. So Shariah audit, like the conventional audit, have their own goal based on the article from Muhammad Iqbal and Mustafa, enhancing Shariah audit practices in Islamic financial institutions in Malaysia. Shariah audit are mainly to ensuring a comprehensive and efficient Shariah compliance internal control system. This statement also can be found in the article of Shariah audit practices in Malaysia moving forward, which are written by Fatihu and others author. Extracted from Yaqub and Dolah 2021, Shariah audit ensure that a sufficient structure of check and balances is in place and it is adapted to the aims and mission of the organization while following the maqasid of Shariah. It can be concluded that the objective of Shariah audit is to ensure that the financial statement is prepared based on all aspects of life following the Shariah principle rules along with the accounting standard of AUFI. Next, I will be presenting about the importance of Shariah audit. So, based on article from Muhammad Iqbal, Hisham Kamaruddin and Mustafa Muhammad Hanifah, enhancing Shariah audit practices in Islamic financial institutions in Malaysia, stated that Shariah audit is important to ensure the Shariah compliance in accordance with fast expansion of IFIS. Agus Awani stated in her or his article, Issue and Challenges of Shariah Auditing in Islamic Financial Institution and Corporate Governance Compliance. Shariah audit is important mechanism as it will be a reflection of the auditor's accountability, not only to the user of the statement, but most importantly to the creator, Allah Subhanahu Wa Taala. In the article also stated that Shariah audit are act as an assurance tool in order to achieve the maqasid of Shariah, which is the objective of Islamic law. Subsequent, the article from Nur Asiyah Muhammad Ali, Zakiyah Muhammadun, Shahidah Shamimi and Zurina Shafi, Competency of Shariah Auditor in Malaysia, Issue and Challenges, specify that the role of Shariah audit from an Islamic point of view is more important as it patterns the responsibility of the auditors not only toward those who have interest for the financial statement, but towards the creator, Allah Subhanahu Wa Taala.
Level of approach. From one of the articles written by Rifki Muhammad, there are three level of Sharia audit approach as set out in the Sharia governance framework. The first level approach is the audit of IFI financial statements should be an independent assessment and objective assurance to ensure a sound and effective internal control system for Sharia compliance. The second level of approach indicates that the compliance audit on organizational structure, people and processes should cover all aspects of the business operations and activities. The third level approach of Sharia audit is the review of the adequacy of the Sharia governance process, in which the Sharia auditor should provide recommendations and communicate the findings and results to the audit committee and Sharia committee. Next, current Sharia audit practices. From one of the articles written by Muhammad Iqmal Hisham Kamaruddin and Mustafa Muhammad Hanifa, the current practices that are related to Sharia audits are the Sharia audit guidance and framework are continually being created and guided by the conventional practice. For example, the current Sharia Internal Auditor Group Constitution of one of Malaysia IFI shows that 4 of the 5 auditors graduated in accounting or auditing, while the remaining 1 graduated in business administration. Next, the Sharia audit practitioners are expected to meet the needs of stakeholders, which was expected that practitioners of Sharia audit practices in Malaysia IFIs are qualified in both Sharia and accounting or auditing related to subjects. This also stated in the article wrote by Mariawati Omar, which was Yaakob and Dongla, stated that Sharia auditor shall be a person that with adequate knowledge, capabilities, and independent to carry out the audit and must have been trained in accounting and auditing as well as in Sharia and Islamic law. Furthermore, Sharia audit should also ensure that the control of Sharia governance is in place. It cannot be stated that all Sharia concerns are being considered while doing current Sharia audit method based on Bank Negara Malaysia Sharia governance framework. For example, if the profit sharing ratio is not included in the documentation for forming a mudarabah account, a conventional auditor might easily interpret this as an audit finding. Unfortunately, the article wrote by Rifki Muhammad stated that the current practices by the Islamic banks were slightly different, which firstly, the regulators do not require any Sharia-related companies to be audited according to the Sharia. Secondly, auditors are still being trained in the conventional manner.
Next, I will proceed to the first case, which is MK Associates Sindiran Berhad versus Bank Islam Malaysia Berhad. In this case, MK Associates Sindiran Berhad had entered into buy Bitamat Ajit agreement with Bank Islam Malaysia Berhad. However, it had default in the installment of Al-Bay Bitamat Ajil. Bank Islam Malaysia Berhad had claimed the outstanding balance of the facility together with ta'wid or compensation for late payment in the amount of 10,384,262 ringgit Malaysia and 88 cents for the periods of 30 months from January 2000 until June 2012. What is ta'wid? It is a compensation on the actual loss suffered by the financier or the bank due to the late payment by the debtor. In this case, there are a few issues arise, which is firstly, whether the defendant was entitled to charge the plaintiff ta'wid pursuant to the agreement. Second, whether the defendant was entitled in law to charge the plaintiff ta'wid. And the third is whether the defendant was entitled to charge ta'wid in the sum of 10,384,262 ringgit and 88 cents. The court finding states that a declaration that the defendant is not entitled to charge ta'wid in law. Second, an order from the defendant to return and or pay the plaintiff the sum the defendant had taken as ta'wid from the plaintiff, which is sum shall be assessed by the court. This was because the respective parties could not confirm the actual amount of ta'wid, which was deducted by the defendant, and or the actual amount of ta'wid imposed by the defendant on the plaintiff in their respective affidavits. Third is the claim for interest is denied as this is provided in Sharia and Islamic financial framework.
So, based on the case Tan Sri Abdul Khalid bin Ibrahim versus Bank Islam Malaysia Berhad, the respondent, Bank Islam Malaysia Berhad, had given 2 murabahah financing office to Tan Sri Abdul Khalid, Mr. Ibrahim, the offended party, empowering the offended party to secure more offer in an organisation called Kumpulan Godri Berhad. The office was subsequently rebuilt to the BBA office following a few breaks by the offended party. In the way of defaulting the installment of the primary portion, the offended party asserted that the bank has misused the BBA office with activities negating the Islamic instructing. Along these lines, he tried to announce the concern to be invalid and void. The litigant has denied the case, depending on the common law and Sharia rule that the arrangement is legitimate and restricting to the 2 players. From there on, the bank completed an obligation recuperation activity against the offended party, expressing that the offended party had defaulted the particular of the BBA of his understanding. These two suits were subsequently combined. Before the combination, the bank applied for a rundown judgment in regard of its suit. However, offended party rejected so. The High Court permitted the outline judgment application. Be that as it may, the offended party spoke to the Court of Appeal, which permitted the allure. Working on it, the broad phase of this united activity, the offended party applied to allow specific inquiries to the Shariah Advisory Council of Bank Negara Malaysia in accordance with Segment 50C of the Central Bank of Malaysia Act 2009. This is because of the way that the offended party have raised Shariah issue, and as per the Act, such issue ought to be alluded to the SAC. It was additionally added that the decision made by the SAC will be restricting on the court. The offended party protested the application. The issue arises are whether there is any question concerning the Shariah matter arise, whether the court is conscious officio for making a reference to the SAC as the question has previously been referred to the same board at the summary judgment process, and whether a reference regarding the Shariah issue arises, if any, can still be made to the SAC. In a view of the conflict made by the offended party and the respondent, it was held that there are Shariah issues exist for this situation and they should be checked by the SAC. For the first time in history of the Malaysia court, that the High Court judge made reference to the SAC for confirmation of the Shariah status of the agreement.
JRI Resources Sdn Bhd versus Kuwait Finance House Malaysia Berhad 2019. So based on the case, it is about the unfairness in applying the Islamic finance contract in Kuwait Finance House and JRI Resources Sdn Bhd, where the bank acquired several vessels under the Islamic finance contract called Ijara Mutahiyah Bitamil. The issue arises in this case is whether it was JRI or Kuwait responsibility to bear the maintenance cost. On April 10, 2019, the Malaysia Federal Court ruled that Section 56 and 57 of the Central Bank of Malaysia Act 2009 are constitutional in the matter of JRI Resources Sdn Bhd versus Kuwait Finance House. Sections 56 and 57 of the Central Bank of Malaysia Act require a court to refer questions about Shariah issues that arise during legal proceeding involving Islamic financial business to the Shariah Advisory Council. Kuwait Finance House Malaysia filed an action in the High Court of Malaya against JRI Resources Sdn Bhd and its guarantors for failure to pay on 4 Ijara Mutahiyah Bitamil facilities and a Murabahah Tower contract financing facility provided by Kuwait to JRI. Thus, the Court of Appeal upheld the appeal and ordered that the case be sent to the SAC, which found that the clause to be Shariah compliance. JRI then filed an application with the Federal Court asking a ruling on whether provisions of 56 and 57 of the CBA were constitutionally legitimate. However, JRI was rejected by the High Court, but the Court of Appeal allowed JRI's appeal and ordered the High Court to make the reference. In a 5-4 majority judgment, the Federal Court concluded that the Sections 56 and 57 of the Central Bank of Malaysia Act 2009 were constitutional and that the SAC judgment under Section 57 did not end or settle the parties' dispute over the Islamic finance facilities.
Now let's move to challenge of Shariah audit. The first challenge is to establish audit evidence. For Shariah auditing process of Islamic financial service, the criteria could be developed based on written opinions of the SSC, the products manual and operating procedure. A major decision facing every Shariah auditor would be determine the appropriate types and amount of audit of evidence accumulated to be satisfied that the client maintain effective internal control over Shariah matters. Shariah audit should involve a systematic review of the operational aspect of the IFIs. The second challenge of Shariah audit is developing a systematic and thorough audit program. In order to audit the IFI, it's necessary to establish a special audit program to compare the discrepancies between product and offer and traditional banking. Shariah audit program could be created to cover a wide range of Islamic financial products and services. The Shariah audit program must also be written in a way that potential stakeholders may understand. Moreover, the third challenge of Shariah audit is to create and competent and independent Shariah auditors. The Shariah auditors must be qualified to understand the criteria used and competent to know the types and amount of evidence to accumulate to reach the proper conclusion after the evidence has been examined. The auditors must have an independent mental attitude. Last but not least, lack of accountability of Shariah auditors. Internal or external auditor can conduct a Shariah audit as long as they have sufficient Shariah-related knowledge and training. Following that, the report is sent to the IFI Shariah Committee. The Shariah Committee may only provide recommendation to the BOD on Shariah issues, and the BOD will determine or make the final decision. Shariah auditors should have been more accountable because they are responsible to a variety of stakeholders. Next, recommendation to enhance Shariah audit practice. The first is roles of regulators and financial institutions, regulators, professional bodies, and associations to undertake the role of setting professional standards pertaining to the scope, definition, setting, and skill sets of Shariah auditors. The need to have a solid framework for internal audit and for regulators to check on a consistent basis that the pool of Shariah talents have been accordingly trained. Regulators to ensure that adequate infrastructure is in place prior to enforcement of any form of regulation pertaining to Shariah audit and governance. Next, skill sets and innovation in Shariah auditing. Internal auditors to have proper qualification and certification to increase their dual capabilities, where they will be able to conduct mainstream auditing and also specialize in Shariah auditing. The needs for auditors to diversify their skills and activities and to become more proactive in their respective roles. Auditors to embrace new technologies to improve the quality of audit, as audit change management program to be developed, which include data management, IT system, and regulatory requirements. Roles of professional bodies and association. Professional bodies and association need to undertake the role of developing talent to address the needs of the industry. For example, via the offerings of professional Shariah certification courses and training programs. Stakeholder engagement is needed in the development of Shariah audit talents. Higher education should consider on giving more exposure to the students. Education and training programs should equip the students with two basic knowledge specialized in Shariah knowledge as applied in Islamic banking and finance, and accounting and auditing knowledge and skills. Two groups of potential entrants will be Shariah graduates and accounting graduates. The needs for a professionally dedicated qualification will be necessary in the long-term view in view of expansion to worldwide. As for the conclusion, the rapid and tremendous growth in Islamic finance require the IFI to have competent Shariah auditors and to provide a check and balance, an equally competent auditor with a thorough understanding of accounting, auditing, and finance, as well as a good comprehension of Shariah and fiqh. They are referred to as Shariah auditors. It is seen strongly important to establish and standardize the qualification and competence requirement for Shariah auditors who are supposed to have minimum degree or professional qualification in accounting and specialized certification in Shariah audit. That's all from us. Thank you.